Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons have business before this court, draw near to give their attention to themselves.
Thank you. Please be seated. The first case for oral argument this morning is 816 People versus Brown.
Good morning, Madam Presiding Justice Smith, Nate Riley of Serial Law Offices on behalf of Mr. Jim Brown, and may it please the court. I'll focus my arguments this morning on the first 2 points in my brief, and I'll try to be as brief as possible. Under this court's decision in People v. Gaskin, prejudice does not apply to the CPL 3030 and 245-21 analysis of whether the people timely disclosed impeachment evidence and prosecuted this matter. This court must accordingly reverse and dismiss the indictment irrespective of prejudice or harmless error where the first certificate of compliance failed to disclose impeachment material as to 2 individuals on the trial witness list for the people, Officers Lynch and Sorrell.
Okay, so let's talk about the law and how it evolved a little bit, if you don't mind. Okay?
Absolutely, Judge.
All right, so it really wasn't until June of 2020 that the legislature repealed the civil rights law, which protected a lot of the documents that you're seeking here, or that the defendant was seeking in Supreme Court or County Court. Okay, and that's actually the argument that was made in the defendant's papers. Now that this is repealed in September of 2020, now that the civil rights law is repealed, now we want to go back and ask for some documents, specifically about the officers that are going to be called in this case, okay?
So I think that with respect to the repeal of 50A, I don't think that it impacts this appeal for a couple of reasons. I think that under we think that under 245-20 subsection 1K specifically, that the people had an obligation to disclose this information because it was within the control of law enforcement. And so the statute specifically says that this is run-of-the-mill Giglio material that we're talking about here. This is standard impeachment evidence that should have been turned over regardless of whether or not 50A was repealed. I think what 50A does is it provides the opportunity for defense counsel to potentially subpoena those records independent of it. But I think independent of whether or not he could foil or subpoena those records, the people had an obligation to turn this over under 245-21 subsection K4. That this was evidence that in the Court of Appeals lingo under Rouse and some other cases, that this was evidence that tends to impeach. And that because it was possessed by law enforcement, there was no reason why the people did not have an obligation to turn it over. And I think that he presses the issue actually slightly after the repeal of that in September, I believe it is, of 2020. My defense counsel below submits this request to the people saying, hey, you got to turn over this information that I haven't received.
And I think they phrased it in a way that they said, now that this civil rights law is repealed, the protections under it, we think we should get some of these other documents. And so it was a chicken or the egg thing. Your counsel below asked us to consider discovery in light of the repeal, okay? It was deemed, I think, a significant change of things by counsel that brought them to make a motion for additional discovery.
And even all right, so let's take up for a moment. If I were to concede that hypothetical and say that 50A was relevant, that was the only reason why he could obtain these documents, the people still waited more than 8 months to turn this stuff over.
With respect to that period, I couldn't help but notice that very little in this case happened between March of 20 and September of 20, and then again between December of 20 and
I think if Your Honor's raising the pandemic, that wasn't...
May of 21. Well, I am, obviously. And the question is, I know that you claim that people haven't relied on it, but does that mean then that they're not entitled to that? I mean, 3030 was told during those periods.
Well, I think any argument with respect to that on appeal has been waived. I don't think that people raised that issue in their brief. I don't think that issue was raised below. But even if it was, again, we're almost past the pandemic at this point, right? We're talking about in October of 2020, there's Teams conferences, there's routine court appearances are being had, and there's an appearance before the court in which the court says, all right, I'm directing you, Miss ADA, to look into these records and to disclose them. And if you have any issues with them, you can provide them to me in camera. And so what the people should have done is, within a matter of weeks, do that. But instead, they waited 8 months from the time of October 2020 to June of 2021, when we're literally on the eve of trial, to hand over these routine Giglio materials. And then the court makes a finding that these items were impeachable. He says that this was information that would be impeachable in this case. And so I think that conclusively demonstrates that this was routine Giglio material that the people should have handed over, that should result in invalidating the first certificate of compliance in this case, in which case the prosecution was untimely. Again, I just can't get past the fact, and I know that they raise this argument of, well, it's a good faith basis for us to have had this meeting of ADAs. That didn't occur until June of 2021, when we're on the eve of trial. So they treated this matter the same as they would have any discovery matter under Article 240, which has been repealed for this much more broad and expansive liberal interpretation.
We have to ignore the toll. When that order came down October of 20, and then the toll started December of 2020 through May, and then the disclosure happened in June, for your argument to be valid, we have to ignore that December to May toll, correct?
Well, again, I don't think that argument has been raised either below or on appeal. And so I think that argument has been waived, but that's certainly an issue that this court would have to consider, yes, is whether or not that any waiver in effect at that time.
Anything further?
With respect to point one, again, I can't get past the unreasonableness of the lack of good faith in this matter, for the people to admit that these records existed in October and then not to disclose them until June. But I understand that the court has that argument. If I can move on briefly to point two, Exhibit 36 depicted 40 minutes of Mr. Brown in handcuff and chains. This is something that would have been completely impermissible had it happened in court, and there's no reason why it should have occurred.
Didn't it
on
occur
videotape.
because that's the procedure that particular police department uses, correct?
Right, so that's what Detective Irvine has to say about it on the stand, but neither the court does not offer any reason why that video needed to be shown to the jury in this case, especially when it could have been expurgated for the audio-only portion. There was only a very small segment of it that was relevant. I cannot fathom a reason why, for several minutes, my client needs to be depicted in handcuffs and in leg shackles, without any questioning going on for the first several minutes of that Exhibit 36 video. He's just sitting there. And it's unquestionably prejudicial to my client and to the presumption of innocence in this case, as the Supreme Court has talked about in Dex and Holbrook and in Buchanan. I think that this is a clear error on the part of the people. And obviously their argument is, my client didn't preserve this argument below, and we provide you an adequate response to that, we feel, in our papers, both in our brief and in the reply, why this court could find that to be a mode of proceedings error, or certainly why it constituted ineffective assistance of counsel not raising this particular issue. And that one issue alone, under the Carrier decision from the Supreme Court, is sufficient for this court to find IAC. And we also ask that you review it in the interest of justice.
Okay, your time's almost up. Do you have anything else?
I think those cover the two issues that I wanted to address today. Just distinguishing Schrock, the jury there could not see the stun belt or notice any discomfort that the defendant felt. And without that, the jury's verdict could not be presumed to be influenced by impermissible factors, whereas here, he could see it, you could see him tugging at it. There was no question going on for several minutes in that video. There's absolutely no reason why this court can't reach that issue. And I understand that the court has the argument. And so as to points 1 and 4, we ask this court to reverse and dismiss the indictment. Alternatively, as to our remaining points, we ask this court to reverse and order a new trial or reduce the sentence. Thank you so much.
Good morning, Your Honors. Brad Osler for the people. With respect to the 245, Article 245 related argument, I didn't hear my opponent mention this at all, but I think this is, and I can't get by this, I think the most critical aspect of the analysis here is discovery that relates to the subject matter of the case.
That was something that I was going to ask about, but...
Well, and Judge, I'll continue on that vein. Officer Sorreo did not testify. I don't see how a witness who does not testify is subject to the 245-21K4 disclosure requirements. That subsection relates to witnesses who testified, so that removes him from that category. Investigator Lynch, who took the buccal swab from the defendant, and that's all he did. He took the buccal swab. It was in open court. It was in front of the judge. It was in front of the defense attorney. I struggle to see any sort of cross-examination that the investigator could be subjected to, independent of whatever sort of disciplinary records might exist in his file. It's just an ministerial proceeding, again, in open court. There's no real question about what occurred. So even if the people were, even if there was a shortcoming in the people's disclosure with respect to Investigator Lynch, and his disciplinary records would have been conceivably subject to 245-21K4.
But they wouldn't have related to the subject
I
matter.
think that is still the shortcoming in the defense argument here, is it just doesn't relate to the subject matter of the case. If he was an investigator of the crime, sure.
Isn't that an argument to be made before the trial judge with an in-camera, which is what happened in this case anyway, right?
Yeah, oh yeah, I absolutely, I agree. I think there is still, the law is perhaps still unsettled with respect to exactly what type of records have to be disclosed or what would be subject to cross-examination. And
You're not suggesting that the people shouldn't make any disclosures to the court at all because they think it's not relevant. It's a decision for the court, and it's an argument to be made.
sure, I think that is going to be part of the pretrial litigation in any given case. Again, in the context of this case, it's just the records in question, and in the officer's role or the investigator's role, just seem outside the bounds of what would be considered subject matter.
Counsel made a deal about the idea that the discovery took quite a while, and basically they got the discovery sort of on the eve of trial. And I wondered about the prejudice, of such late discovery.
Judge, my reading of the case law that exists now, and obviously much of it is still at the trial court level, is that the people need to meet their obligations under 245-50 first, being that it is a reasonable and good faith, the disclosure, our certificate of compliance is made in reasonable and in good faith. Once that hurdle has been met, then it's an analysis of whether there exists any prejudice under 245-80. Even if I think the question of whether the disciplinary records relate to the subject matter, that I think speaks to 245-50, and whether there's any prejudice then would be the 245-80 analysis. And if we look at the case, I mean, my argument's a little bit, it's kind of circular or the same here, but it's, again, there's just no evidence of any prejudice, and I can't, even kind of speculating what cross-examination might have taken place, I don't see any that could exist.
Why don't you go down to the issue about the shackles?
Judge, I would note, as we've mentioned, it is unpreserved, and I would submit that it is subject to, at the very least, constitutional harmless error analysis. In this instance, we're looking at it from a somewhat removed perspective because it wasn't live in front of the jury in the courtroom. It was a video depiction of it in a questioning context. I think trying to move down the road that this was error that requires reversal would sort of go hand in hand with the rule that I would submit as inappropriate, that the jury be entirely insulated from any hint or mention that a defendant was ever handcuffed, shackled, put into custody in any way, shape, or form. And I think that's going way beyond what we would consider the current rule that we have from the Court of Appeals or just all of the jurisprudence that flows from that. If there was an objection here from the defense in terms of showing that video,
Could have been dealt with at that point.
they could have dealt with it at trial, but I think the lack of objection, if we were looking at this, say, under an ineffective assistance standard, it's one of those strategic decisions where how much attention do we want to call to something that really I think it's very reasonable to believe that no juror is going to view or see a depiction of handcuffs and suddenly decide that he's guilty from there. So I don't see the error in this context.
Thank you.
Unless you have questions, thanks.
817, People versus Newton. Just hold down just a minute. No problem. I didn't finish that sentence until you know what I'm saying.
I understand.
Great. Okay. Okay, go ahead, Mr. Belsier.
Good morning. May it please the court, Stephanie DeGiorgio on behalf of the appellant. I'm going to keep it brief this morning and focus on points 1 and 3 of the brief. With respect to point 1, during the people's direct examination of their key eyewitness, the witness was questioned regarding his statement that he gave to police and also the testimony that he was going to be given at grand jury and then subsequently at the trial. When he was questioned, he detailed that he wasn't given any promises with respect to giving his statement. He was just advised that the police would look into the charges that he had pending. But when he was subsequently asked, and I quote, "Was there a deal made after you gave your statement later on?" He responded, "I'm not sure if it was really a deal, but they did look into my case like they promised they would." And when asked again, "Okay, and was that deal made with the DA's office and your defense attorney?" He said, "Yes, sir." The people then said, "All right, for you to testify truthfully," and he said, "Yes." It was very ambiguous as to whether or not the witness received a deal, which he in fact did, as disclosed by the people in their notices. But it was not clear what that deal was. It was implied that he didn't receive a deal when he gave the statement, but he did subsequently receive a reduced charge and likely a reduced sentence for testifying in this case. Even the judge the judge commented during the jury charge that the testimony was unclear and he wasn't sure whether or not there was a deal given. And I would submit that because this was the people's key witness that tied the property to the defendant, that it was important impeachment testimony that should have been made clear by the people. They had a responsibility to...
They found this, the 50 Funko Pop doll, and they found it on the defendant, correct? And the 3 distinctive swords?
Yes, I believe they were found...
It is residence.
Correct, but I believe the defendant testified that those were objects that he regularly sold or traded.
It's quite a coincidence.
It is, but I would submit it was this witness's testimony that I believe was the most damaging. He placed the property directly to the defendant. He made some comments as far as the defendant's statements to him. The other evidence, I believe there was video evidence depicting him on screen, but he was living in the area, and then the DNA...
We'll look at that very carefully.
And then just with respect to the DNA evidence, I note that the defendant also gave an innocent explanation for his...
Is it 2 years before or some years before he'd been over there?
Yeah, I mean, it wasn't rebutted by the people, but he did give that explanation that he'd been in the house before. You know, it was a friend of his.
But wasn't it where it was found on the windowsill that people argue as to why his explanation didn't make sense?
Well, I submit, I mean, it was, strike that. I would suggest that how it came out during the people's case, it was unclear where it was found, whether it was found on the edge, the outer edge of the windowsill, whether it was found on the inner edge. So that wasn't clear. I would submit that if it was made clear that it was found on the inner edge or the outer edge, it would have been more explicit as to what we were looking at for evidence of the entry. But I submit that if it was on the inner window portion of the windowsill, whether that was totally on the window ledge, I mean, the defendant's innocent explanation of that would submit. With respect to point 3, I would submit that the sentence was enhanced for the defendant exercising his right to trial. During a pretrial conference, the offer by the people was a 5 to 7 year determinate sentence with 5 years post-release, and then after trial, the defendant was sentenced to 2.5 times that, to 15 years with 5 years post-release. I note that there were no facts that the people weren't aware of, you know, after trial.
We'll look into that.
And then just lastly, I would have to ask the court to consider whether or not the sentence imposed was unduly harsh or severe. Unless the court has any other questions, I rest on my papers. Thank you.
Mr. Bell?
Yes, good morning. Your Honors, Matt Bell for the people. First, I would like to state that the plea deal was in fact disclosed to defense counsel in pretrial motion, so he was well aware that Mr. O'Connor did receive a plea bargain deal in exchange for his truthful testimony at trial. And certainly at trial, Mr. O'Connor did state initially that he was not sure with respect to a plea deal being made in exchange for his truthful testimony at trial, but he did say that he believed that they looked into his case. At that point, I was the trial prosecutor, so I'm going to say that I asked him if the deal that he said that the police would look into was in fact made, and he replied that yes, it was, and that he received a 2.5-year state prison sentence for attempted robbery second. So he did confirm, Your Honors, in fact, that a deal was made in exchange for his testimony at trial. And the court did, in fact, on its final instruction to the jury, did mention that and clarified any potential confusion if the court finds that there was some confusion. I didn't believe there was at the time. And certainly the defense attorney knew ahead of time the exact specific details of the plea bargain that was made with Mr. O'Connor, and clearly could have went into it
You've gone over that.
cross-examination.
Well, can you go on to the DNA?
Yes, Judge, the DNA evidence, he was indicted on this case, and the people made a motion for him to compel a DNA swab, as he initially refused to do so. His DNA was found, and I believe the trial record will confirm this, that his DNA was found on the inner part of the window sill that was the point of entry for the burglary, where a exterior window had been broken and someone had stepped up on some bricks and entered through the window to commit this burglary, and that the DNA was found on the interior of that window sill. So when he refused to provide a sample, the people did make a motion that the court granted, and that DNA swab was entered into the CODIS system, which is the combined DNA index system.
We understand all that. but
Yes, okay.
The question is, what about his explanation of how the DNA got found there?
Well, Judge, he did testify at trial, and he did explain to the jury that he had been in there approximately 4 to 5 years prior, when someone else had lived in that house prior to the victim in this case, and that he must have touched that window at some point when he was in the house. And obviously the jury rejected that testimony and did not believe him. Because, I don't know exactly why, but certainly 4 or 5 years prior for DNA to exist there, that's a questionable.
And what about the sentence?
The sentence, Judge, he initially was offered a plea to attempted burglary second as a second felony offender, which would carry a 5-year minimum, 7-year maximum sentence. And Judge Hafner, the trial judge, did explain that to Mr. Newton, and Mr. Newton rejected the plea deal. And so a promise was never made to Mr. Newton by Judge Hafner with respect to would he give him 5, would he give him 6, would he give him 7. We never got that far, Your Honors. And, certainly he did receive the maximum after the guilty verdict did come back in this case. He had a terrible record. He had 8 prior felony convictions on 5 separate dates.
So you certainly don't think it was harsh and excessive?
What was that, Your Honor?
You don't think that this sentence was harsh? Is that
Okay. Sure.
Anything further?
Just, Judge, the way the evidence argument, first of all, I don't think there was, acquittal would not be reasonable just due to the strength of the case. I think if Your Honors look at all the facts here. There was overwhelming evidence of guilt, including admissions, video evidence.
We'll look into all that. Anything
Okay.
further?
No, judges, thank you so much.
Thank you. 818, People versus Ocasio.
Good morning. May it please the court, I'm Tanya Plank for Augustin Ocasio. I submitted 2 additional case citations yesterday. I apologize for the late submission. The first was People v. Fernandez, which is the defendant's co-defendant's case decided by this court in July. And I just want to point out the waiver of appeal was held to be invalid in that case. And so by the same logic, it should be, the waiver of appeal should here be held invalid too. Same written waiver, same oral colloquy. The second case is People v. Misone from the Court of Appeals around 1992, I think. And I would submit that that case stands for, that case, under that case, the people's express concession here that that defendant had standing over the warrant, that the eavesdropping warrant that had his name and phone number on it, that basically waived, that waived the requirements of 71060, which Misone says that because 71060 is a statute meant to benefit the people can waive the requirements in it. So I would argue that this is a waiver of that. And clearly, Mr. Ocasio did have standing. There is a warrant there that's bearing his name and has his telephone number and his conversations.
And counsel, it's just the one warrant, though.
One warrant, right?
Right.
Right.
That's the only warrant he is standing on.
Right. That I know of from
Right.
looking at the contents of the
Well,
drive.
because he also challenges the search warrant with respect to the basement, but he doesn't have a privacy or proprietary interest in the basement, does he?
In the basement, well, that's arguable. I mean, but.
Well, what is his privacy or proprietary interest in the basement then?
In the basement, well, that it's curtilage and he had access to it.
Okay.
And so I believe he had standing to challenge both, although the co-defendant might have, but he did. And he didn't get any kind of probable cause determination. So we would request that this court at least remit to the trial court for a probable cause determination. And in the event that you decide not to remit, we ask that the court hold off until the Bruin decisions come down from the Court of Appeals, since 2 of those issues are involved here.
Thank you.
Thanks.
Good morning, Your Honors. Lisa Gray for the People. The People did not concede standing below in their motion papers. The prosecutor specifically in her motion papers indicated that it was, Mr. Ocasio didn't specify which of the various warrants he had standing to contest, or in fact was contesting any of the warrants. It was a broad...
Well, the response was the people didn't object to standing with respect to phones that he utilized. In the face of that one warrant, indicates that it's the defendant's phone, right?
I think what the people were saying to the court in its response was that it was acknowledging that if the defendant could articulate what particular line he was using or what telephone conversation he was a participant in, then yes, he could establish standing. But the motion papers, as submitted by counsel, had absolutely no specificity with respect to which of the eavesdropping warrants he might have been contesting. And even the court in its decision, when it went through its analysis... But the defendant here says
you specifically didn't challenge any phones that the defendant used, and the warrant says we want to look at the phone the defendant uses. It's parallel.
The court in its analysis said, listen, if in order to get to the search warrant at Avery Street, the court had to look at the underlying eavesdropping warrants that were in part of the probable cause that went to support the search of Avery Street. So without anything more with respect to what defendant might have been seeking to suppress from whatever lines that had been maybe used by Mr. Ocasio or whatever telephone conversations that he may have been a party to, that went to support the search warrant without any sort of articulation in his own papers. How is the court to make any decision with respect to whether or not there was standing to contest eavesdropping warrants, of which there were multiple lines in this particular investigation with multiple subjects. So I think the people's comment in her moving papers was an acknowledgement that yes, if he can identify, then he would have standing, but his motion papers were completely silent with respect to standing. And the court went on to conduct its inquiry. And also, I would remind this court that, this was a nuanced investigation with respect to, like I said, multiple telephone numbers, multiple eavesdropping warrants that culminated in the search of this Avery Street location. There were different areas within Avery Street that were searched. So on its face, without more in the defendant's moving papers, it was almost impossible for the court to, or the people to respond with respect to probable cause and standing. There was, as to your point, with respect to the basement, there certainly was no standing to contest the search of the ceiling duct in the basement, and yet the court correctly found that Mr. Ocasio certainly had standing to contest the search of the upstairs apartment. So again, this wasn't a straight up search warrant. It was nuanced. There were certainly different locations. There were certainly different aspects of standing which could go to certain locations. And Mr. Ocasio's moving papers were almost completely silent with respect to any of that. So unless there are any other questions, I would ask this court to affirm Mr. Ocasio's conviction in its entirety. Thank you.
820, Sandy Martin versus Gary Martin. It's going to be on video.
Oh, I'm sorry.
You don't have to be sorry. There we go. Can you please unmute yourself? Can you unmute yourself, please? Thank you. Go ahead.
Yes, sorry about that. Good morning, Your Honors. My name is Kellyanne Argy. I am here on behalf of the father, Gary Martin, in this matter. And I will keep it brief. I would just like to point the court's attention to a few reasons why this decision is erroneous. First, it is based solely on the mother's prior diagnosis. A thorough review of the record will reveal that it's not based on the mother's current condition. And in fact, there is no proof of a current condition. And it's not based on the children's best interest. It's actually tied to money. And specifically, there's a couple of items in it where the father, who, yes, is incarcerated, but he's ordered to pay an additional $25 over and above the modified payment of $25 a month in order to have telephone access with his children. The decision incorporates after incarceration, it can increase to 2 times a week phone access, but also only if he pays an additional amount of, above and beyond the support.
Has there been any visitation between the father and the children?
I'm sorry?
Has there been any visitation between the father and the children?
Only the phone access as outlined in our brief. This referee also points to an erroneous piece that the mother only had to provide transportation to the father in the prior order only if he paid support, and that's not in the prior order. So there's many reasons to review this decision. He also removes complete access for the father, and an additional statement is made on whether or not it's the paternal grandmother should even have access to the children, none of which is in this record. This court is very well aware that in its own decision, Stewart v. Soda, that the family court erred in terminating visitation between respondent and his children because respondent failed to pay child support. That is not to be tied to access to your children. It is
Well,
well
the
established.
court didn't deny visitation. The court put in place some specific visitation with regard to, phone calls and things of that nature, visits with the paternal grandparents. Is Dad still incarcerated?
I believe Dad is now out.
Okay, on
Yes.
parole?
Yes, which of course includes the fact that he cannot physically leave the county to be able to have any physical visitation with the children. But I'd also like to point the court's attention to the fact that even though there is phone access granted, it is contingent upon additional payments. And it empowers the mother to restrict access. If you look at the full record, you'll see that she has Facebook posts that that are admitted into evidence that show that she was 7 years cancer free, not really having any problems, but disgruntled because Dad wasn't paying child support. We know he was incarcerated. Dad completely acknowledges and accepts his situation, but he wants to be a father. And to empower a mother to restrict access through support payments is completely erroneous. And I think
Counsel, were they support payments, or were they meant to offset the costs of the phone calls and the access?
I think I understand that that's a way to read that. I do get that can matter after incarceration, but during incarceration, that referee knew full well that the father would not be able to come up with an additional $25, that he already had the order modified to be $25 because of his current situation. And the referee also heard from the father that as soon he had already lined up work at his union and he would be paying the arrears, which were only about 4 to 6 months. Granted, can be a lot of money, but the father did not provide any evidence on the record supporting the referee's kind of twisted piece that if he doesn't pay, he should not have access. He has indicated he will make those payments, and he most certainly did not provide any other and the mother did not, the mother did not provide any other evidence to show that he would not make them.
Thank you. Mr. Sarandon.
Thank you, Your Honors.
John Sarando on behalf of the respondent, Your Honor. My calendar showed that the appellant was going to be here. That's why I was surprised not to see her in the courtroom. Briefly, the referee properly allowed the mother to relocate, and insofar as the father's preserving the relationship with the father, apparently there were two whole calls while the father was in jail with the children.
Since he's been released, do you know if there have been communications between the father and the children?
No, I don't. The father in the order was allowed to arrange his own contact, phone or through the electronic media, and what the calls would be Wednesday and Sunday in accordance with the order. And obviously if the father is not getting that, the avenue would be to go back to family court and enforce the order. Insofar as I think the mother...
Counsel, didn't the father do that? Didn't the father make a petition saying that he was being denied the phone access? Isn't that part of the December petition that the father filed?
But we're talking about after he was out of jail.
Correct. Because of the difficulties that it would have been to make the enforcement petition while he's in jail. As soon as he was out of jail, didn't he make the claim that he was being denied his access, including the phone access?
I thought he was in jail when this was taking place, Your Honor. Insofar as the health of the mother is concerned, I think when you look at the father's testimony itself, he readily testified as to the mother's medical condition and the necessary assistance she needed. And it was the father's position that he could come, his family in Clinton County could come to assist her where she was all alone in Jefferson County, as opposed to being with her, the other side of the coin being that she would be with her mother, who was a very primary caregiver for the mother.
But so he substituted his own help, so to speak. He says, listen, you can have my mother come help you, instead of she wanted her mother to help her.
And the mother now has, I think, a better support network. But the most important thing, I think the record reveals that the best interest of the children was to move from Jefferson County, whereas the judge or the referee indicated they were almost wards of the state. And hopefully down in Tennessee, they're not wards of the state. And other than that, we'll rely on our brief.
Thank you.
Thank you.
821 through 823, in the matter of Tara Malish versus Jeffrey Ryan.
Good morning, Your Honors. I'm Michelle Brown. I'm the attorney for the Mellish-Rennie children. I won't take long. First, I know when there's a matter involving children, the court likes to know how these children are doing. These are great kids. They're great. They're accomplished. They're smart. They do well in school. They do well in sports. They're great kids. Unfortunately, at the current time, they're in the middle of a debate between their parents, yet again, over a trip to Barcelona. That matter is subject to an appeal before this court to be heard in February. I want the court to know that subsequent to the decision below, which dismissed Mom's petitions, that my younger client was accepted to the Buffalo Academy of Performing Arts. It's interesting to note that because in her pleadings, she asserted repeatedly that this boy needed to take the entrance exam for city honors, that it was important to his self-esteem. Father declined to allow him to take this city honors entrance exam for the third time under the theory it wasn't a good fit for this child. As it turns out, ultimately, Dad was right, Mom was wrong. It wasn't a good fit. But what Mom tends to do is she tends to assert her opinion repeatedly. Yes, Your Honor.
I have a feeling like we're sort of getting way off the point of what this appeal is about. And although we enjoy hearing that the kids are doing well, that I'm sure we're all happy about. But I view this appeal as a very narrow appeal about whether Mother made the appropriate showings in her petition to have the court actually take some testimony and hold a hearing on the issues, okay? On your behest, you asked the court to dismiss the petition, and now we're reviewing, and the only thing we're reviewing is whether that was the right decision based on the papers in front of us. And so I'm glad that the kids are good.
Thank you, Judge.
But I also don't necessarily agree with your progression that because Father didn't think it was a good fit, that it's not a good fit just because he wound up going somewhere else. I don't want to get into that because I don't think that's an issue for us. So can we have some discussion on what's before us?
Yes, I think, first of all, I think there is the narrow issue on whether or not Mother's pleadings set forth a change in circumstances. I argued it did not. I made the motion. Mother argues that I didn't take the children's side in this proceeding and that I violated my ethical duties. But I've made very clear that the children only wanted two things: a minor adjustment in their schedule, which Mother refused, and for this to be over. So I fulfilled my ethical obligations by making the motion to dismiss.
But didn't both parties concede that there was a change in circumstance? The father and the mother both said that in their papers.
Mother argued there was a change in circumstances.
Right.
Father actually moved to dismiss Mother's petition about a year before I moved to dismiss her petition. So no, I don't think he inherently agreed. Yes, Your Honor.
He made a cross petition, and at which time he suggested that there was a change of circumstances. Now, he did offer to withdraw that, that's all well and good, but he did actually, also cross-petition on the same basis that there's been a change.
I think your honors have to look at the whole record, though, and the whole record of petition after petition with the same allegations repeatedly.
Okay, so we have to look at, I think, whether those are the same allegations, or perhaps whether they're a progression of allegations. Curiously enough, the judge, before you made your motion, the judge expressed an opinion that there was enough here facially to go forward, and then you got involved, and you hold a great deal of weight in our town, I'm for sure, okay, but then she changed her mind.
Because a year had passed, Your Honor.
Okay.
And in that ensuing year, the kids continued to thrive. So even if there was a change, there was nothing to be done to enhance the children's best interest by a change in the schedule. So it's a two-part test. Yes, Your Honor.
The 2019 order that's now in effect. It's
Correct.
back in effect, March 6th of 2019. My review of it, the best I can tell, is that it provides for joint custody, spheres of influence, no parenting coordinator, which was a change right near the end.
Correct, Your Honor.
And that's where we are, right?
That is correct.
And we've had both parents claim that it's not workable, particularly the joint custody piece of it.
But that's exactly what the spheres of influence was designed to address in 2019. In areas where they couldn't agree, one parent would have the authority to make decisions.
And if they were to claim it's not working out for us, we're still fighting about every little thing every day, what more do they need to show?
Your Honor, even if custody was changed, these litigants would argue about everything.
Okay, we'll look at that.
Thank you, Your Honor.
824, in the matter of Trevor Castle versus Stephanie Barnes. Flo, you need to unmute yourself, please.
Thank you, Your Honor. My name is Brian Degnan. I was the AFC for the trial in Orleans County Family Court for the child Evelyn Barnes. A little background here. Ms. Barnes was the prior custodian of my client for most of her life until the trial in the custody matter. A little further background, she was the subject of an Article 10 case.
We know all the background.
Okay, very good. Judge, the real issue here is the sound and substantial basis in the record that the appellate raises, and the court went on its way to make a finding of 16 specific points. And the biggest issue that I want to raise to the court is the domestic violence that occurred. The mother was a massive victim of domestic violence. She landed in ECMC as a result of her boyfriend and father of the other children, Jamie Dutton. She was in the hospital for over a week.
So again, we know all that.
Yeah, I just want to make the impact of domestic violence known, Your Honors, along with the mother's lack of understanding and being unapologetic of the domestic violence. She's a victim, and she went on to argue that she's a perpetrator of the domestic violence.
And you think we should be affirming, is that correct?
Pardon me, Your Honor?
You think we should be affirming this case?
Absolutely, without a doubt, Your Honor. So the other issue that the appellant raised was interesting about the court not setting additional visitation or a holiday schedule. I think that is something that would be important for this court to take a look at. My client did provide a Lincoln hearing, and I do think Orleans County lost sight of setting additional time for the mother, just in an effort of fairness. Dad did not have that set in his prior order, but the mother always did work with the father in affording him extra time, and would just ask the court to use its fact-finding powers to look at that issue.
Thank you.
Thank you.
825, Reyes versus Episcopal Senior Housing.
Good morning, Your Honors. May it please the court, Tim Bellavia for the plaintiff appellant. I think I'll be brief if I could. At all times in this case regarding Labor Law 240, the plaintiff was working with his supervisor. There was not a moment that he was not without his supervisor. When that window was left unsecured, after they both removed the metal flashing and the caulk, that window was unsecured. And at that point, the supervisor, who was the only one authorized to operate the scissor lift, lowered it to the ground and allowed my client to go to the bathroom. In addition, with regard to the...
This all goes to whether or not your client could be a sole proximate cause of anything, since the two of them traveled in pairs in this case. Okay?
That's correct, absolutely, Your Honor. At all times they are together, and this court has numerous precedents, which I put in my brief over and over again. Where
Even if we didn't have a pairing here, okay, there was also a problem with the window being left in that condition, and it's a violation of the statute, okay? And so that also would militate against the idea that the plaintiff would be sole proximate cause.
That's absolutely correct, Your Honor.
Because they can't occupy the same territory.
Space. That's
Okay.
exactly correct.
I think we have your argument.
Thank you, Your Honor.
Good morning, Your Honors. Nice to see you. I won't promise to be brief as everybody else have, but I will be. James Milbrand, Barclay Damon for Flower City Monitors. The employer in this case. I'm not arguing against Mr. Bellavia. Okay. After Justice Bannister's questioning, I'm definitely not arguing against Mr. Bellavia. But I think Mr. Bellavia might even admit there's not a grave injury here. Grave injury is defined in the workers' comp law to protect employers, right? It's the sole remedy, as an amputation, blindness, deafness, something like that. And then there's the section of an acquired brain injury. And if it goes to that, we need proof of that. And what can we have as proof? We can have medical testimony, we can have IMEs, we can have treating doctors. But you know what the proof is in this case? He went back to work for 4 months. He went to the hospital, he treated, a couple days later he came back, he worked. We have that. Then the season ended, and he was let go. And what does he say to his supervisor? If you let me go, I'm going to sue you. And he followed through. I'll give him credit for following through. That's the best evidence that he's not totally disabled. The next best evidence that he's not totally disabled are the doctor's opinions. The treating physician, the IME physician. He may be partially disabled. He may be totally not permanently disabled, but he's not totally permanently disabled and unable to work. That's the key here, Your Honor. That's what they need to prove a grave injury. And quite frankly, the judge below was correct in evaluating the evidence and saying there is no grave injury.
Thank you.
Thank you.
826, Jeffrey versus Fayette Romana Central School. You're recused on this one? Okay. So we need to get, hold it. We've got some recusals and back from recusals.
Welcome back.
He's not paying attention to you.
John Sarando on behalf of the appellant. This is an appeal from the dismissal of a defamation action regarding the conduct of the school board. There's, I know the court is very familiar with the facts, but I have to, by way of background, and I'll be brief, Your Honor. Lisa Deneen, in a prior administrative meeting, indicated that she had a reliable source and started the rumor about my client. Lisa is a special education coordinator who had an ongoing issue with the plaintiff since he was the whistleblower as to how she conducted state mandatory survey as to services for special needs
And
children.
again, you know, we know all that.
Right,
And it was
and one of their
because
children
his
was this.
children,
Okay.
child.
Now, we get to this, to the board grouping. I'm going to call it a board grouping because it wasn't a meeting of the board, which would allow them to have their immunity. And we've all been on boards where we go into executive session in accordance with the public officers law. That was not done in this case. There was no executive session. And they've indicated that, well, maybe it's just those of us talking, the board members just talking, but there's an indication from, I think on page 160, 164, 165, that there were other people in the room. So it wasn't like.
Counselor, the issue that's in front of us is whether these defendants are protected by immunity.
Right.
And they're clearly officials, they're school officials. And if they're school officials, the question that's run of us is, was this conversation in furtherance of their duties, right? That's the real question that's front of us. Not where they are or kind of, were they carrying out their duties as school officials?
I don't think they were. Their language, what they were talking about.
They were talking about, there was a conversation about, from your perspective, a potential attack, that someone said someone was gearing up for an attack on the school.
Well, what it was
And if that's true or not true, you're saying that conversation's not furtherance of their duties?
Yes, because when the conversation was that a reliable source told me that the plaintiff bought his son a gun. The plaintiff's son was not even a student at the school. There was no gun purchase. And more importantly, Your Honor, the superintendent indicated that he knew it was false, and he said there was no safety concern. So by them trying to bootstrap that into an official, it's more like they're gossiping with a malice intent because of that started with the coordinator. So I think when you consider that the young man graduated the year before, he was not a student, it was not in an official proceeding, no gun was ever purchased, it was not a safety matter, but it scared some of the people that is it a safety matter? And I don't think they.
We'll look into that, Mr. Stern.
Huh?
We'll look into that.
Oh, I know you will. In addition, we submit that there was no other purpose for that remark other than malice. And I think the Vice Mims indicated that she had seen it on a parent-to-parent website, but then there was a question whether it was taken down sooner than that. So, and she indicated that there was no relevance to safety. So it would set a very bad precedent to say that, well, these individuals were school officials, and they can talk about anything they want. And the unfortunate climate, the next question probably would be to me, the unfortunate problem of gun violence in schools that Judge Karolounis indicated in her decision. But Tice was not concerned with that because he knew that it was not a safety concern. But he said it anyway.
Okay, I
So-
think we have all that.
I know you're going to look at it, but it's just, it's not proper analysis, with all due respect, just to say, well, they're school officials and they said it. That's not the law, I don't think. You have to look at what they said and why they said it and the basis for why they said it. And they even said that this Deneen lady had even said that the parents allowed their son, the special needs son, to stand out in the light in a rainstorm with a lightning rod in his hand.
You know all that.
I know you know. But you have to highlight it, because I think it takes away from the shield, school official shield. You all go back and you have your conference and you talk about cases. And I'm sure that if, that's all protected, obviously, but I'm sure if you started talking about something that was not related to your cases, or you knew something was false, that's almost the same analysis that we're trying to have this court follow. Thank you.
Thank you.
May it please the court, Don DiBenedetto for Dr. Tice and the Fayetteville Manlius School Board. It's our position that Judge Karolounis's decision should be affirmed based on each and every ground she raised, and I believe there are 4 separate grounds, the first of which is that the statement made by Dr. Tice, and just so the court's focus, this case is based upon one statement that Dr. Tice made to the board members, and only the board members, and it was made only after he received a phone call from the school attorney recommending that he share this information with the board. First, let me address an issue about whether there were any other people present. There's no evidence in the record that there was anyone else present but board members. One board member said he thought that perhaps Mr. Kilmer might have been present. He wasn't sure. He didn't remember. And Mr. Kilmer was the high school building principal. So I would submit to you that even if Mr. Kilmer was present, and there's no competent evidence in the record that he was, because everyone else said it was just board members, that wouldn't change the court's analysis. But what I think is important to note is that Dr. Tice had been made aware of these 2 pieces of information, or rumors, or however you want to characterize them, and he didn't have an intention to discuss any of this with the board until he got a phone call from the school attorney. Now, the school attorney had gotten a phone call from another board member just prior to the school board meeting who had also heard the rumor about the gun and expressed some safety concerns. In response to that, the school attorney called Dr. Tice and advised him, because of a commonly accepted principle that no one in this case disputes, that when one board member has a concern or has some information, it should be shared with the entire board. So based upon the advice of Attorney Ferrara, whose affidavit is in the record, Dr. Tice disclosed this information about the gun, the alleged purchase of a gun, to the board members and only to the board members. He didn't disclose the other information that he had heard about this lightning rod, which I think is very relevant to the issue of malice. Dr. Tice had there's no evidence of any malice whatsoever, and in fact, Mr. Jeffrey, when he was asked what the motivation was for Dr. Tice to have had this communication, he said, I have no idea. But in any event, this communication that's at issue here was made by the superintendent of schools, who's clearly protected by an absolute privilege, to the board members who he reports to about a potential issue of school safety. The fact that Dr. Tice didn't believe personally that there was any issue of school safety isn't determinative of anything, because other people may have had a different view, and Dr. Tice it was recommended to him by the school attorney to share it with the board and allay any concerns that they may have. I do want to make sure the court, I apologize, it's not in my brief because this court hadn't made the decision yet, but there's a case of Panic versus Brantner, which this court decided this past summer, in which it found that a school superintendent was protected by an absolute privilege when she discussed with students their concerns about the termination of their cross-country coach. This court held that the superintendent in that case was protected by an absolute privilege. And
I know, I was on that case.
okay, I was there too. The case clearly presents a qualified privilege. Clearly, for the same reasons Superintendent Tice had an interest in this subject matter, as did the members of the board, and there's absolutely no evidence of malice. Moreover, as Judge Karolounis found, the words that were actually spoken by Dr. Tice are not defamatory. It's not defamatory to say that someone purchased a gun for their young adult son. Only when you add in all the innuendo that the plaintiff wants the court to assume was said would you get to where the plaintiff wants to go. But the critical fact is that this whole case is based upon some hearsay characterization of what Dr. Tice did or said or didn't say, because the complaint says when he was asked, do you think there's a threat to the school, the complaint alleges he stood there in silence. That could only be based upon the statement from Kim Swanson, who's the one who told plaintiff's wife about this whole conversation among the board members. But she admitted in her testimony that while she heard the question to Dr. Tice, do you think there's any risk or threat, she didn't listen to the answer because she was engaged in a shouting match with another board member.
We know all the facts.
And Dr. Tice said, no, I don't think there's anything to be concerned about. And finally, the only publication of this statement outside the board members was by the plaintiff himself, who testified that after he heard about this discussion, he went out and told all of his friends, colleagues, and even went to the press to talk about this conversation between the superintendent and the board members. Thank you.
Good morning, and may it please the court. Allison Fute with Hair Speech on behalf of the defendant, respondent Marissa Joy Mims, who was a board member, actually the vice president of the school board at the time of the discussion at issue in this case. I'll try to be brief and try not to repeat what counsel just reiterated, but I do want to point out that the appellant's argument that the ongoing matters concerning the appellate's family and the board did not turn that, everything related to that family into public matters. I mean, that ignores the fact that the statements were not made to the public, but were made in a confidential context, and further ignores the reality of the circumstances that face the board, specifically in grappling with a new rumor concerning a family that had two pending disputes ongoing with the board at that time. And contrary to the assertion in appellant's reply brief, that our brief mischaracterized the charges against appellant's wife that were pending at the time of the statements for second-degree criminal assault. Appellant did not contest the statement in Ms. Mims' statement of material facts that Mrs. Jeffrey was awaiting trial on second-degree criminal assault charges. And he also did not contest that the incident involved a physical altercation, specifically the allegation that Ms. Jeffrey threw an envelope at a board member and resulted in her nerve and her wrist being bruised. Also, just with regard to Ms. Mims' statement in particular, any allegation that there's evidence of actual malice on her part ignores the fact that the only reason that she was inclined to speak at all was because the conversation had been initiated by the superintendent, who all of the board members are responsible for, with the superintendent carrying out the school district's functions and operations. And as a result, the Supreme Court properly concluded that there's no evidence of malice here. And briefly, with regard to the defamatory nature or alleged defamatory nature of the statement, in the appellant's initial brief, he argued that the Supreme Court erred in finding that Ms. Mims did not speak the bracketed language that's attributed to her in the complaint. But in his reply brief, he concedes that that language was not in fact spoken by either Dr. Tice or Ms. Mims, and rather the substance of the bracketed language was the intended meaning or insinuation. So appellant essentially is self-defining the word situation as used by Mims to mean what Dr. Tice did not even say, but merely insinuated. This circular and convoluted logic is not a basis to disturb the Supreme Court's finding that Ms. Mims did not speak the bracketed language, and as a result, without that language.
I think we have that.
Okay. And with regard to, one more point on defamatory nature is that the appellant has not responded to Mims' argument both below and to this court that her statement, the alleged statement attributed to her, does not even convey an accusatory fact about the appellant. Very briefly on the issue of damages, which was another basis for the Supreme Court's ruling. Appellant's reply brief is the first time in this appeal that he has argued that Supreme Court erred in finding that the defamatory statements do not constitute defamation per se, so I'd submit that the court should decline to consider that argument as it was waived by not him raising it in his initial brief. And I think once you establish that this is not defamatory per se, you have to establish some type of financial damages, which appellant really all but concedes there is none in this case. The only evidence he's citing in support of some type of financial damage is that someone told him that he was completely unemployable due to this incident, and I submit that that is insufficient to support raising a triable question of fact, and we would request an affirmance in all respects. Thank you.
Thank you. 829 Lentner, Philip Card, and Maryland Card versus Upstate Forestry. We need to just wait for a minute. Judge Greenwood? Okay.
Good morning, and may it please the court. David Johnson of Gerber-Chiano Kelly Brady for the appellants, Upstate Forestry and Development, and Charles Nowak. Your Honors, we would like to focus the court's attention on a very specific issue on which this case hinges. The interpretation of a contract that is specific, unambiguous, and complete in all respects. The contract sets out the parties, the product involved, the price, the place of performance, and a period
What about the
certain.
maps? Where do they come in?
They are outside of the written agreement. There is no reference to maps or any other document set forth in the written timber sale contract. The only evidence of maps comes from the testimony of the respondents, and within the written agreement that was signed by the title owner of the property and our clients, there is simply no reference to any other documents or evidence that's needed to complete the agreement at issue. The court below denied our client's motion for summary judgment based on a determination that the contract was incomplete. However, the basis that the court cited, that the place was insufficiently described in the contract, was never raised by the respondents. There was never an argument raised by the respondents that the property that was described in the contract was vague or unclear. There's never been any claim that Upstate Forestry and Development or its assignees harvested timber from a property other than the property that was located at 839 Newport Road, where the title owner did not reside, but wrote on the contract. Finding that incompleteness in the contract, the court looked to the parole evidence that completely varies the written terms of the contract. Now, I would also like to address the arguments that respondents brought up, even though that's not what the court hinged its decision on. The respondents themselves never identified any other incompleteness or ambiguity in the written agreement. All they did was point to their own self-serving parole evidence to try to create an ambiguity where none existed in the written agreement. At most, there was a collateral agreement that itself, as a matter of law, cannot be used to vary the terms of the written agreement. Now, unless your honors have any questions, we are content to rest in our briefs.
Thank you.
Thank you for your time.
Good morning, Your Honors. David Benz of the Chain Law Firm on behalf of the respondent. Your Honor, may it please the court to really address the main point here as raised by the petitioner, the appellant, is a question of this contract and whether it's sufficiently unambiguous, fully integrated, and such that you do not need to look at parole evidence. I would submit that the court below correctly found that there is ambiguity, that it is not fully integrated for a number of reasons. The contract is a one-page document. It's got some handwriting in some terms that are very general in nature, that clearly leave contemplation for the surrounding circumstances and other representation of the parties to determine what is supposed to be done by the parties. For instance, there's a provision that says we'll clear access for future development for the land, for the property owner. What does that mean? Where's that supposed to be? Again, that's just a very general term. That's just one example.
But there is no merger clause in this contract.
That is correct. Absolutely no merger clause.
And there is no reference to this map.
The map itself is not referenced on this page of the document, but there was a representation made in the argument of my opponent that essentially the only evidence we have as to the existence of map is a self-serving testimony from my clients.
Well, I don't know, but there's a map, but does that have anything to do with the contract?
Well, that's.
Is that part of the contract? I guess that's where I'm struggling.
Well, that's what it says. We say it was because of the fact that there were certain representations put on that map by David Isabel, who was the recognized agent of the defendant, in this case, the appellant, as to, we say, is that clarifies the nature of where this logging was to occur, how the payment structure was going to be. Because yes, the contract does speak as to $15,000, $15,500 for payment for logging. We acknowledge it says that. We acknowledge receiving $15,500, but we're saying that is a payment for the portion that was agreed to. Essentially, this property was carved up into 3 sections.
Well, essentially, your client's saying what we agreed to is what's on that map. And what they're saying is, we only agreed to what the contract said. That's what we agreed to.
They're saying that, yeah, they're interpreting this first page in it without reference to the map. And one of the major points that I think needs to be made is the fact that David Isabel, who was, again, the agent in this respect, he was the person who went and actually had all the communications with my client, made the representations, and led to the actual contract being entered into. In his deposition, admitted that he presented a map to my clients, that there were markings made on that map, and that it was his understanding that those markings determined or had played some role in what was to be done on that property. So by his own admission, and this is again an agent of the defendant, that map was supposed to be part of this whole arrangement. Now there may be
That doesn't mean it was part of the contract. It might be something they were discussing, but it doesn't mean it was part of the contract.
Well, I think a question of fact goes to that point because he interpreted, or his testimony, I believe, indicates that this is supposed to be part of the arrangement because it depicted exactly what was to be done, what was not to be done.
No lawyers were sitting around with these folks?
Correct. Unfortunately, yes. Neither side had counsel at the time, so we're left with a very, again, what I would argue is a very general, short, brief contract that has ambiguity that I would argue is not fully integrated. It doesn't have a merger clause. When you read this in terms of the terminology of what's supposed to be done, it's not completely clear. Again, it does not reference exactly where the logging is supposed to occur. I know there's an argument that it's supposed to be the whole property, but again, this is a 300-acre parcel.
I understand all that, so we'll look at that very carefully.
So that would be my argument on that point. The only other points I'd very briefly touch on is the timber theft argument, the timber theft claim. There's an argument that because we asserted a breach of contract claim, we can't also raise a timber theft argument. I would argue that our interpretation of the contract, our understanding of the contract, again, it was that essentially you had a portion to be logged for a set price, a portion where logging would occur, and my client would be compensated on a fee structure based on stumpage, and then a portion that was not supposed to be touched at all. And so the timber theft argument, if that is accepted or found ultimately at a trial to be the true contract arrangement, that portion, the northernmost section, in this case, should not have been logged at all. It was not part of the contract, which means any logging that occurred thereon is subject to the timber theft statute. And then the last point is just the idea that Mr. Nowak perhaps bears no individual responsibility and therefore should be let out. I would submit that the court below, I think, correctly found that there's a question of fact in this respect. The contract itself never actually represents the LLC that apparently he has. It never identifies him as, in his capacity. There was a reassignment contract to a third party. Even in that contract, nothing actually indicates the true entity's name or that he's executing it in his capacity there versus an individual capacity. Thank you.
831 Arnold versus Town of Camillus. Yes. Judge Del Conte is accused on this matter.
Good morning. My name is Robert Strum on behalf of Plaintiff Appellant. May it please the court. What we have here is two statutes.
I've got a question for you right off the bat.
Okay.
With regard to the state tort causes of action, they've been dismissed in the federal district court, correct?
Yes.
Okay, so where do you stand on that now? Are you going to pursue those in state court, or are you done with those?
With respect to the state tort claims other than the human rights law claims, yes, those we agree cannot be pursued due to the dismissal on the merits.
Okay, thank you.
The real issue here we have are two statutes. One is titled Presentation of Tort Claims. The other is titled Presentation of Claims for Torts. And they're virtually identical. The first is 50I of the General Municipal Law, which applies to personal injury, wrongful death, or damage to real or personal property claims. Town Law 67, titled Presentation of Claims for Torts, applies to claims for wrong or injury to person or property, or for the death of a person. These statutes say the same thing with the words slightly mixed around. The significance of this is that the Court of Appeals in Marjoram versus the City of Buffalo in 2015 definitively said that human rights law claims do not require a notice of claim under 50E or 50I because they are not torts, they are not personal injury or wrongful death or damage to personal property claims. As such, the decision below finding that Town Law 67 applies to the human rights law claims in this case is clearly erroneous and inconsistent with the Marjoram decision. The case law cited by the court below and by respondents on appeal is almost entirely, or is entirely, predating Marjoram with respect to the state court cases and includes some more recent federal cases that simply rely on state court authority that predates Marjoram. The main decision on this issue cited by the court below is Picciano v. Nassau County Civil Service Commission, which is a second department decision from 2001. That case was a case against a county, so dealt with county law, but in dicta said that Town Law 67 applies to human rights law claims. Subsequently, courts have applied that dicta and held that, as in this case, human rights law claims require a notice of claim even against the town, despite the fact that they are not torts.
Okay, so why don't you go to why you think that you should have leave to file a late notice?
All right. Well, as you noted at the beginning of the argument, that the tort claims have been dismissed. So our argument is that we should not need a late notice of claim because Town Law 67 doesn't apply.
What if you did?
However, with respect to the three main factors for the late notice of claim, knowledge, prejudice, and reasonable excuse,
I'm certainly going to say, you're going to say that clearly they had knowledge was given to them repeatedly, correct?
There were complaints as early as February 2018 to the chief verbally, January 2019, a written complaint in February 2019, as well as the PBA put the town board on notice in a March 2020 letter. Plaintiff noted her concerns in her exit interview in March 2020. And I think most significantly, the defendants, the police department, hired an investigator to look into this. So
certainly had knowledge of it, and what about prejudice?
As far as the prejudice, as noted, they had an investigation. Any prejudice would likely be due to flaws in their investigation. The main thing that respondents point to as prejudicial is the inability to conduct a physical examination of plaintiff. But to date, they've never sought any physical examination, and I don't understand how a doctor wouldn't be able to parse the different injuries from a broken leg versus discrimination and harassment.
I'm also going to ask you about the reasonable excuse. That one's kind of weak, wouldn't you say?
Well, I don't agree that it's a weak excuse. Now, first of all...
Would you agree it's the weakest of the three.
Of the three, yes, I would agree, it's the weakest. However, plaintiff faced a real fear of retaliation. As noted in our papers, the city of Syracuse, where she subsequently was employed, has a judicially determined custom policy and practice of retaliation for individuals who complain of discrimination. Should she have, for any reason, not been successful in her probation under civil service law, she would have returned to the town of Camillus in her position under the same harassers, the same individuals that she was seeking to avoid any more retaliation, avoid any more harm.
I think we have that. Thank you.
And the only other thing I'd note is just with respect to the respondent's collateral estoppel argument, the notice of claim issue was not before the federal court. The only issue there was whether the claim should be remanded for this issue to be decided by the state court.
Well, federal courts have never said that this is subject to notice. This is only a second department dicta. Federal courts are probably saying this is a supremacy clause and there shouldn't even have to be a notice of claim.
Well, with respect to any of the federal authority on this issue, they simply rely on the state court decisions. And the actual statute shows an intent by the legislature, I believe, to keep this a state issue, because with respect to the late notice of claim, only state courts are empowered to grant that leave.
Look, but we don't have a Court of Appeals or Fourth Department case on that, do we?
With respect to town law, I have not come up with any specifically on this, besides, of course, marjoram, which I've argued is essentially the same logic.
Thank you.
Thank you.
I did this the second department, didn't I?
Why were you on it then? Or you?
Good morning, Your Honors. May it please the Court, Ksenia Prima Bonchanakin King, on behalf of defendants, respondents. With respect to the first issue, I think the case law is very clear that Section 67 of the town law requires a notice of claim to be filed before plaintiff can pursue
What if we agree with you on that? Why shouldn't they be able to file a late notice of claim?
I'm very pleased to hear that you may agree with me on the first issue.
I'm not saying we do, I'm saying if we did.
So assuming the court agrees, with respect to plaintiff's request to file a late notice of claim, the court below ruled that plaintiff is not entitled to that relief. In order for plaintiff to succeed on this particular argument, they have to show that a clear abuse of discretion by the lower court, and plaintiff cannot even come close to making that showing. For example, with respect to the undue delay, as you pointed out, very weak argument, right? The only argument that they really put forward is that plaintiff feared retaliation. However, at the time plaintiff filed a complaint, she was already successfly employed with the city of Syracuse. Actually,
How do you argue, though, about the knowledge? I mean, how many times did she have to bring these complaints?
yes,
to the
very
department?
good question. With respect to knowledge itself, it's not enough, right? So plaintiff also needs to show that the defendants were aware of damages and injuries to plaintiff, and there is a lot of case law on that point.
And in the original complaint, she did mention, and all through, she mentioned that she was traumatized, she had this and that, she did mention all this.
In her complaints to the town of Camillus, she refers to anxiety generally and being uncomfortable. There is no specific allegations regarding the alleged injuries she sustained.
Discomfort, dread?
Discomfort, yes, there is a word discomfort in her complaint, but it doesn't necessarily put the defendant on notice that she has compensable injuries in that case. So that's our position, and there is case law supporting that in order for plaintiff to show the knowledge element, they also have to show that we were on notice of the actual injuries and damages. And here in this case, after she complained, complaints were resolved to her satisfaction. We had no further complaints from her. And in fact,
I believe there were a lot of complaints.
The first complaint that she made was in February of 2018, and she specifically asked the town of Camillus to keep it confidential and not to pursue it any further. When she complained in February of 2019, the investigation was conducted and her concerns were addressed, and she did not bring any further concerns to the town of Camillus.
Look at
She
that.
resigned voluntarily in August of 2019 and submitted an unsolicited resignation letter in which she was very complimentary to the town of Camillus and thanked them for all the opportunities that the town provided her in terms of training her and progressing her career. So, I mean, that particular fact, I think, hurts plaintiff very much in terms of giving town the knowledge of injuries and damages and, potential lawsuit action. And so based on that, I think plaintiff cannot show that when this evidence was available to the lower court, that the lower court abused its discretion in concluding that plaintiff did not show reasonable excuse for filing late notice of claim.
Look at that very carefully.
And so, and with respect to prejudice, which plaintiff also needs to show in order to
They did investigations, they hired people to
Yep.
look into it,
So-
so what prejudice could there possibly
Absolutely.
be?
So in terms of conducting an investigation, the town did commence an investigation and was looking into the allegations made by plaintiff. However, plaintiff refused to participate in the investigation. So if the plaintiff refuses to participate in the investigation, we cannot prepare our defense, we cannot possibly address plaintiff's allegations. So I think, again, that factor shows prejudice to us because we had no participation from plaintiff whatsoever. She said she's not going to do it, and we couldn't force her at the time. And in terms of further prejudice to the defendants, we could not obtain a timely medical examination of the plaintiff, right? Because she delayed filing a notice of claim by almost a year. During that period of time, she sustained a serious injury while working for the city of Syracuse. We also had COVID pandemic, so that could have had some, mental health issue impacts as well. So there were a lot of intervening events that occurred during that year, and we were not able to obtain a prompt medical examination of plaintiff to see what her injuries were at the time that she resigned from the town of Camillus. And again, there is case law saying that where this is the case, then yes, defendants are prejudiced, and plaintiff should not be allowed to file a late notice of claim. Thank you very much.
832, Kelly versus Prohaska.
Counsel, if you could proceed.
Okay. Morning, Your Honors. If it please the court, John Collins on behalf of the plaintiffs in this action. As the court is aware, the dispositive issue on this appeal is defendant Snap-on Credit engaged in the trade or business of renting or leasing motor vehicles within the meaning and intent of the Federal Graves Amendment, which was enacted in 2005. Supreme Court said yes, and for that reason dismissed or granted summary judgment, rather, in favor of defendant Snap-on Credit. Plaintiffs submit that the court erred and that this court should reverse. The term engaged in the trade or business of renting or leasing motor vehicles is not defined by Congress in the Act. There were no hearings, reports, and the phrase I submit is not clear and unambiguous in its meaning. But I think the Congress's intent as to what it means can be gleaned from the remarks of the bill's, or rather the amendment sponsor, Representative Graves, and the other proponents who briefly spoke about the amendment on the floor of Congress before it was, then.
Counsel, we've read
Yes.
your brief, and we've read what you say happened there.
Mhm.
My question is that really a fair representation, what happens on the floor of Congress or some legislative body, and then what is actually reduced to writing? Sometimes they don't actually appear to be the same thing. Is it fair for us to infer that from legislative intent?
I think it's fair and necessary, Your Honor. I think that, I cited both federal, and this is a federal statute, so there is federal authority that the remarks of a sponsor are, definitely a good indicia of what Congress intended when it used certain language. And,
Even though it didn't wind up being part of the legislation?
well, you know, the act was read on the floor, according to the congressional record, and then the sponsor, Representative Graves, and various proponents spoke about it. And, you know, they didn't say in so many words, we intend that engaged in the trade or business of renting motor vehicles means this, but they did refer to, you know, the renting and leasing industry, and indicated that they wanted to restore and foster competition, lower costs for consumers, increase choices for consumers.
In fact, doesn't the congressional record reflect that the concern was really that certain companies are renting vehicles that go into different states?
Yes, that was one of the concerns.
So if Pennsylvania doesn't have a vicarious liability statute, the insurance on a rental vehicle in Pennsylvania should be less than in New York, where it would. But a rental company, one of the larger outfits, wouldn't have a control as to where they could go. So isn't that really what this amendment was all about?
Yes, I think, you know, for what they call the renting and leasing industry, or, you know, the business of renting or leasing motor vehicles, they wanted a nationwide standard as to, and essentially, you know, barring the imposition of vicarious liability on a state-by-state basis. But it really did go to, you know, the fostering and protection of, you know, the business of commercial renting and leasing companies who rent or lease vehicles to customers on the open market. And I think, you know, to answer Justice Bannister's question, yes, you know, you have to look and should look at what these, you know, Congress people said as to what, you know, the whole intent was. And I think it's telling that Congress could have simply said that anyone who leases or rents a vehicle to another shall not be held vicariously liable.
Right, but they also could have said, this only applies to rental car companies, and they didn't say that either.
Well, they did say that it applies to entities in the business of renting or leasing motor vehicles.
Right, which you concede does not, you know, is not defined.
It is not defined.
Right.
And I think it, you know, its meaning can be gleaned only by looking at what, you know, the remarks of the proponent and supporters, you know, indicated.
And I know Justice Sotomayor has talked about not relying on legislative history and relying on statutory history for the specific reason that these statements are very politically self-serving by politicians. And if, you know, and after the fact, this could just be something that one of the legislators wanted to appeal to his constituents, but it's not really what the legislation, why everybody voted for it and it became law.
Well, I think if there was any form of, you know, legislative history as opposed to what was said on the floor, that might, you know, have some weight. But I think when there were no hearings, there were no reports, it was simply introduced on the floor. The proponent said, you know, what the goal of the amendment was, you know, intended to achieve, and it did not. It covered, as I said, you know, commercial leasing where there's competition in the market, and the, you know, arrangement here simply doesn't meet any of those indicia of, you know, what the act was intended.
Counsel, let me ask you a question. This is a nationwide law.
Yes.
But we don't have any other case from any other state even, much less New York, that stands for the proposition that you're advocating here this morning.
But there's none, I think, that, you know, would, you know, indicate that what plaintiffs are advocating, you know, should be rejected. I think it's a case of first impression under these facts where you've got, you know, a very specialized piece of equipment that, you know, it's, you know, it can't be, you know, rented or, you know, the defendant Snap-on Tool or Snap-on Credit will not rent it or release it to, you know, anyone other than a franchisee. There's no competition here. Franchisees can look only to Snap-on Credit to obtain it.
Okay, we knew
So-
all that, Mr. Collins.
Yeah, so I think that therefore,
It would be a case of first impression, is what you're
it
saying.
will be a case of first impression. And I think that when you look at the limited history, which is, gathered strictly from what the proponent said, he could have been as expansive as he wanted. The proponents, and introducing, congressmen could have been as, stated, clearly that it covers this kind of situation.
Okay, I think
It
we
was
have
very
all those
limited.
arguments. Do
So,
you have anything
thank you.
further? No? Thank you. Whoops.
Good morning, Joe Darren, Kenny Shelton, Libtech Noack for the defendant respondent Snap-on Credit. I think something that wasn't mentioned, but it needs to be, is that this is a question of law, and the trial court correctly determined down at the lower level that a question of law cannot be sent back to a jury. But that is exactly what plaintiff appellant is trying to do. This summary judgment was found that Snap-on Credit was not in the business of leasing vehicles, and it is also a statutory interpretation question, which inherently cannot go back to a jury. And all the cases that plaintiff appellant cites to in his brief, the Stiegelman case, Brown, DeVito, those all went down in the First Department on separate issues of fact, not the fact that these companies were questioned as to whether or not they were in the trade of renting or leasing vehicles. Unless any of the judges have any questions, they would rely on.
I have one question. With respect to the claim that's being made that this really applies to any company that's just leasing vehicles in any way, shape, or form, if we were to construe it that way, you don't need that first condition at all, do you?
No, I don't think you would.
So Congress should have just struck it. They should have just taken it out. And you're asking us to essentially ignore it.
So what we're looking at, and it was kind of alluded to during plaintiff appellant's argument, is that the statute says what it says. And if all you need to do in order to be within the statute is be a title holder of a vehicle, and you are engaged in the business of renting and leasing vehicles, that's it. Now, there's no exclusivity language that says you need to, 50% or more of your business needs to be renting or leasing vehicles. That's, it says what it says. So I'm not asking you to ignore it, I'm asking you to say Snap-on Credit is clearly within the statutory limitations of what the Graves Amendment stands for, and they are leasing a vehicle, even though it is in an intercorporate bubble, but it's still a company leasing a vehicle for protection under the Graves Amendment.
So you want us to read the Graves Amendment as an owner of a motor vehicle that rents or leases a vehicle to a person shall not be liable if the owner of the motor vehicle rents or leases the vehicle to a person.
I'm asking you to read the Graves Amendment as it stands.
Right, but the whole point is that it seems to me the way you're asking us to read it, we have to find that the first condition is unnecessary. And I don't think we're supposed to do that. We're supposed to find that it has some meaning. And that's what we're grappling with.
Sure.
What's the meaning of it? So there has to be some sort of engagement in a trade. And if it's beyond just me renting you a vehicle, if I have to be engaged in some sort of a trade to get the benefit of that, what does it mean? It can't mean nothing.
Right? Sure.
So what does it mean?
So it means that as long as you are a company that is leasing vehicles to somebody who's going to drive that vehicle, that's the person that is the company that is engaged in the trade of leasing vehicles.
So if I lease a vehicle to you and a vehicle to Mr. Collins, then I'm in it. So it has to just be 2 vehicles? Is that what it means?
No, I don't believe that's what it means at all.
Is it 10 vehicles?
No. I get what you're saying, Judge, but
Okay.
I think that what the statute clearly states is, I understand that there needs to be a trade that you're looking for, but that is not defined in the statute or the floor arguments that were brought up by plaintiff appellant. They focused, right.
Talked about the industry, talked about this whole state problem.
And with regard to the floor arguments that were made, if you really read down, they are really focusing on the rental industry and the consumers. This is completely separate. Leasing industries. That's what I think that the floor argument, kind of talks about more so in terms of the rental industry. Obviously, the leasing industry language is in that statute, but
I'm with you on the consumers. Why should folks in Pennsylvania have to pay more to rent a car when the insurance is much less in Pennsylvania than it would be in New York, because there's vicarious liability in New York, and I get that. And that all filters down to the consumers.
Sure.
But it still then applies to the rental industry nationwide, which is what Mr. Collins is claiming, that that's what it means.
right, and I wholeheartedly see where he's coming from with that argument, but again, when you're looking at a statute, the statutory language is what you have to go by. And there is no legislative history, as was pointed out earlier. There's no statutory history. It's just floor arguments and then
think
a
we have
vote,
that.
and that's that. So
Thank
if
you.
anybody has any other questions. Okay, thank you.
833, DeSalle versus David Hills and Letitia Johnson. We just have to wait just for a minute.
Yep.
There we go. Okay.
Good morning, Your Honor. May it please the court, Rob Taylor on behalf of plaintiff appellant Delilah DeSalle. So for the most part, I will leave it to the papers. I just want to focus on what the real key issue here is. And obviously, in plaintiff appellant's opinion, that is whether or not defendant and defendant's insurance carrier was evading service or at least attempting to frustrate service. And the key points I want to bring up, if you look at the ownership info with the county, there's nothing tying defendants to this property. The only way we even found out these defendants were involved was through conversation with the insurance carrier, which was achieved by sending a letter of representation to the premises at which the accident occurred. So all evidence that we received, again, is from the insurance carrier, and the only information we have from them is that they own this premises and that they reside there. We have no other documentation, again, even tying these defendants to this premises. So as a result, obviously, that is where service was
Did
attempted.
the insurance carrier tell you these people reside there?
They did not explicitly say this is where they reside, but they did say they own this premises. And that, again, that's how we got their information, period. Again, if you look at the...
Is ownership of the premises enough?
Not necessarily, but again, if you look with the county, there's a company called Integra-Key, which is alleged to own the premises. Again, there's no information, and the address for Integra-Key is a third address that has apparently nothing to do with anything. So again, all the information we have, again, it doesn't tie defendants to it in any way except for the representations of the insurance carrier. And so they did not provide us with the address of defendants. The only time we found out the address of defendants was actually at the time of this motion. Okay, so really, and that brings us to actual notice. Ordinarily, obviously, if there was not this issue of evasion of process or service, actual notice of the suit is insufficient. However, in a case like this, again, where there is no other way for plaintiffs to have ascertained the identities of defendant, much less their address, actual notice does become relevant.
Okay, so you say there's no other way, but, and I'm going back to my experience as a Supreme Court judge, people would sometimes come and ask for alternate ways to serve, or ask for alternate people to serve, or ask, in this case, probably more, apt to serve the insurance company.
Right.
Now, and none of that was done here.
I do agree with you. That should have been what was done. There should have been a motion. But pursuant to CPLR 308.5, the court can also order the service to be done nunc pro tunc, which again brings up the point of the actual knowledge of the suit. There's no reason for the service to be done again, given that defendants have had actual notice of this, and they even admitted that they got a copy of the complaint at the premises. So they knew about it for a year and then waited until...
Some relative lived there.
Yeah, it was a tenant. I don't know if it was a relative or what. They indicated it was either the second floor or bottom floor tenant. I'm not sure which. But again, in addition, like I said before, our letter of rep got to them through being submitted to that premises. So again, all the information that was available to us, including representations from the insurance company, to even get these defendants' identities, was relegated to this premises. So, yeah, right. So like I said, again, the whole issue is ordinarily that would be insufficient, but given the attempted, at least evasion of service, I think this is quite relevant. Obviously, public policy is in general, to allow cases to be decided on the merits whenever possible. And, if we ignore, I don't know what's going on with the ownership situation.
I think we have that.
Thanks.
Thank you. Mr. Johnson?
Yes, may it please the court, my name is Thomas Johnson. I'm from Bailey Johnson and Peck. I represent the defendants, respondents in this matter. I think the critical issue is whether the plaintiff's counsel had any justifiable reliance on the misinformation that they received from the insurance company, which only said that they insured these two individuals as owners. Mr. Taylor, I think, forgets the fact that even before that conversation took place, the plaintiff's counsel had documents in their possession which showed that the owner of the property was this Integra Key LLC. These were tax documents. It has the deed and page number on it. One would only have to get the deed to determine who the owner was and serve them as the actual owner. It never turns out that Mr. Hills or Ms. Johnson were actually the owners of this property, and certainly no representation was made that they resided there. That was clearly a complete assumption made by the process server, and well within the time in which this matter could have been corrected. Well,
counsel, let me bother you for 1 second.
Of course, please.
Obviously, they thought that there was something here. Somebody was calling them up and offering them money. Okay, so based on the complaint and based on the fact that it got to them, et cetera. So can they rely, I guess, on the fact that they have an insurance company who's not correcting them, okay, but is nevertheless offering them some money based on this lawsuit, the presence of the lawsuit, et cetera?
Well, I would have to say no, Your Honor, because there's many reasons why someone may engage in settlement negotiations, but there'd have to be some statement that these people resided there. I think we all know that simply because an insurance company believes that they're insuring somebody as an owner doesn't actually create that set of facts. It seems to me incredible that a counsel would rely on a statement or an email made by a claims rep or even the head of claims as to that, to then ignore the information that they already had, that there was an LLC that owned this property, and to then not, do some further action to determine whether that was the case. We see no further investigation by the plaintiff's counsel into this ownership question. When they failed to file the affidavits of service, to complete the service, which would then have brought this issue up in a much more timely manner.
I think we have that argument.
Right. So if there isn't any further questions, I would rely on the brief. I mean, it's a relatively simple question of reliance, and I don't think, with all due respect to Judge Bannister, I don't think the fact that the negotiations went on, it would be sufficient. Thank you.
Thank you.
Thank you. 834, Van Ostren versus Latham.
May it please the court. This is a post-divorce action for fraud. There are abundant flaws in how the husband's motion was handled that require reversal of the dismissal order. I believe that Mr. Steinberg concedes that summary judgment was improper, but argues that dismissal under 3211A7 can be considered failure to state a cause of action. The difficulty with Judge Gallagher's order is that we don't know for sure what theory he was operating under. Both his oral ruling and the written order are abrupt, and as I state in my reply brief, opaque. The order said that it was dismissed with prejudice. That's a 3212 dismissal for summary judgment. But procedurally, this was barred. There was no even joinder of action in this case. The husband filed a motion to dismiss, didn't request any discovery, didn't put in an answer, made a motion to dismiss. Summary judgment is absolutely barred it's my contention. So the only other action is 3211A7, failure to state a cause of action. That has to be decided viewing it in the light most favorable to my client. And it was not. There were abundant issues of fact in this case, including issues having to do with reasonable reliance, material misrepresentation. These are noted in my reply brief on pages, there's two cases cited on page 6 and page 15, Brunetti and Braddock.
Counsel, let me stop you for a second. I think I understand opposing counsel's contention to be that the wife knew about, your client knew about all these things before she signed. She knew about some of the irregularities, some of the money not being accounted for, some of the gold pieces not being accounted for, and nonetheless, the agreement was entered into. Can you talk about that?
Your Honor, they signed the agreement in April of 2021. There had been a meeting, a private meeting, that the Ms. O'Byrne, his attorney, had not been present at. But she said that there was this meeting in which my client got his client, the wife got the husband, to say that there were just 20 gold ingots. And this somehow, from December to April, became part of that separation agreement. There was questions over how many ingots there were. And it turns out that there's 100 ingots that are missing and that were finally revealed.
Weren't there 120 ingots and they were used to purchase the marital residence later, after they were sold?
It's not clear. The husband represented in the separation agreement that the total amount of ingots ever purchased by him in the marriage was 20 ingots. He represented that there were no ingots ever purchased. The wife eventually found 53 pages, I believe it is, of proof, of documentation that he had purchased various types of ingots. Now, that was signed in April of 2021. There is an email that the wife sent the husband in July of 2021 that's part of the record, while the divorce papers were being compiled, in which she said, there's something hinky going on here. I don't know what's going on, but she was suspicious at that point in July, about 3 months after the April agreement had been signed. The divorce still went through. She then brought an action, actually a motion, just 3 months later. 3 months after the separation agreement was signed, in December of 2021, she brought her first motion. Her first motion and her second motion were inept. They were procedurally barred. You have to bring a plenary action. And she did not do so until she hired an attorney later in 2022. So that is the chronology of events. The wife had some suspicions, and she articulated those in a July 2021 email to the husband, but she was still accumulating information in order to do so. And finally brought in this procedural thing in December of 2021. So that is the chronology of what she reasonably relied on. Now, as I said...
But getting back to the ingots, weren't they purchased from the business?
Apparently there were 20 ingots that were on the business that he represented. There are other ingots that he purchased. What they were used for is unclear.
But we talked about that a little bit before, whether they were purchase for the house or not, but where did the funds come from? Didn't they come from the business that she was a joint owner of, or no?
And the bookkeeper.
She was a bookkeeper, but she stated in the record on page 238, paragraph 6, that her knowledge in this area was really quite limited. But I can't answer that question, Your Honor. I don't know if that is part of the record. I don't know that it is part of the record.
Do you have any?
Sorry. Specifically, it seemed that the wife had filed a motion during the pendency. Now, this is prior to the April 14th agreement, and she did include the forensic evaluation showing the $211,000 of missing funds. But then she also attaches an exhibit, the invoices showing the purchase of 120 gold ingots. So the wife proffered that motion. She did this pro se, but she proffered that motion where she had the invoices in hand for the 120 gold ingots. Then later, April 14, 2021, the husband represents in the agreement that there were 20. So the wife knew that there were 120. She's the one that proffered it.
Your Honor,
she didn't raise it at the time.
Your Honor, the wife's pro se motion was she first brought it in after the divorce. It was in December of 2021. She was aware at that time, after the divorce had happened, that there was this very significant disparity. But I believe that is the correct chronology.
Thank you for clarifying.
And finally, Your Honor, the last point I would make is that given how the judge treated this case, this rather cavalier approach to handling this case, which involved $400,000 to $500,000 in issue, and he treated it as a small claims case, and I submit that the case deserved far better, my client deserved far better, and that this should be remitted to a different judge. Thank you.
Thank you.
May it please the court, Michael Steinberg for Peter Latham. It's actually pretty clear what the judge did here. If you look at page 4 to 5 of the record, which is the order, he says that Ms. O'Byrne, on behalf of Mr. Latham, moved for summary judgment or to dismiss the complaint. And then he says, there's been ratification, and I'm dismissing the complaint. The judge really determined, basically, there was documentary proof here that this woman had no cause of action. Yes, it is certainly true that we view the complaint in the light most favorable to the plaintiff. But what is it that you look most favorable upon? You look upon the facts alleged. I mean, I could bring an action that says, Judge Del Conte defamed me and I've lost lots of money, and I put in no facts. It would not survive a motion to dismiss. Okay. What she's alleged here is that I didn't get adequate explanations for my concerns. There is nothing here that shows fraud. When Justice Bannister asked Mr. Muldoon about the chronology, he left out the beginning of the chronology, which is that years, at least a year before the separation agreement was entered into, every one of the $200,000 issues had been raised in a letter that Michael Ray prepared. And in fact, that Michael Ray prepared with the assistance of schedules produced by Ms. Van Ostrand. She had years in which to pursue this. She had experienced, and I might add, aggressive counsel who chose in the end not to pursue them. She then took the benefit of a distributive award that gives her more than $1 million, and she sued to enforce it. All of that is in the record. All of that is documentary proof. Most of it was submitted by Ms. Van Ostrand herself. And the court therefore properly found that she had ratified this agreement.
Anything further?
Yes. The April something hinky statement that Mr. Muldoon relies on is, in fact, a couple of months before Ms. Van Ostrand's attorney submitted a judgment of divorce to the court, which did not raise any of these issues. If her attorney had a genuine concern that there was something wrong with this agreement, He had every opportunity to bring it up before the court. He did not do so. As far as the gold ingots go, this is really hard to figure out what exactly she means. Is it the 120 gold ingots that were bought by the business? Because those 120 gold ingots were not bought by Mr. Latham. And therefore, the proof that she has of these gold purchases refutes her claim that Mr. Latham had bought these on his own. And then at some point she backs off and she says, well, there are other ingots involved. What other ingots? There isn't a shred of proof, this is entirely speculative, that somehow there are ingots that aren't these 120 ingots. And it's just those 120 ingots they were for dental use. But we know from the record that 24 karat gold is too soft to be used for dental work. So they had to be the investment, and therefore the investment was an open book. She had all the records.
And that's your point. She had all the records.
She had all the records, and in fact, I wasn't there. I don't know how the 20 ingots figure came up with, but she herself says, at the time he said that, I had invoices showing only 24. Well, okay, 24 isn't 120, but 24 is different from 20. And if she knew there were more than 20 ingots when she accepted that, she could not have reasonably relied on it. The judge was right. She had her chance over and over and over again. Mr. Bethune said, well, she needs discovery. It shouldn't have been dismissed without discovery. She had more than a year of discovery, of the opportunity for it. She never did any of this. She decided not to pursue it. She accepted the benefits of this agreement, which were very favorable to her. She should not be allowed to come back and undo it.
Okay, thank you very much. 8:30, John P.M. Doe versus Barbara Hauk, and we have two people going, right? We have Judges Delconte and Justice Greenwood are recused, and Justice Ogden will be stepping in. So if you can wait just a moment, okay? We're also waiting for Ms. Wang, correct? There you are. Great.
Marion.
Go ahead.
Good afternoon, Your Honors. May it please the court. My name is Jennifer Wong. I represent the appellant, Barbara Hauk, in this matter. I'll be brief. Your Honors have my brief and reply brief in relation to this appeal. I'll address
Can I ask you a question right off the bat, though?
No problem. Go ahead.
This is a threshold issue for the statutory interpretation of all this, all right? Does the text and purpose of the Child's Victim Act require that the conduct constitute a specified sex offense under the current penal law or the criminal law as it existed at the time of the conduct?
As Judge Tate did address that in his decision in order, and it's our contention that that has not been appealed, cross-appealed by the plaintiff in this case, and it's our position that it had to be the penal law as it existed at the time of the acts. So in other words, in this particular case, it would have been the year 1980.
Okay. I'm sorry, I'm going to ask your opposing counsel the same question. I just wanted an answer to that. Go on.
So in that regard, the Judge Tate found that two statutes that were named by the plaintiff did not revive the CVA claim, one of them being the statutory rape penal law code, which was 130.25, and the forcible touching, which was penal law 130.52. It's our position that those are not in contention on this appeal. Those were found to not revive the statute. The one that is on issue on appeal is penal law section 130.55. And it's our position that this statute was not clear as written in 1980 to provide Mrs. Hauk or others similarly situated to know that she was could be charged with this violation. And this is in contradiction to Judge Tate's finding that there was clear phrasing that that statute applied to both females and males, because the word he could either be male or female. It's our position, number one, this statute, as we briefed, was amended in 2001 to become gender neutral, and it added the word she to the statute, and it became a person is guilty of sexual abuse in the third degree when he or she subjects another person to sexual contact. And so it's our position that it wasn't clear at the time that she could be charged with this, so she could not have violated this. Secondly, the plaintiff goes through a protracted analysis of how this statute were to be read by someone in Mrs. Houck's position back in 1980, that being that she should have read it to mean a human being is guilty of sexual abuse in the third degree when he or she subjects another human being to sexual contact without the latter's consent. And we say a person of ordinary intelligence would not be able to understand that that's what that statute meant back in 1980, and therefore that her claim, plaintiff's claim is not revived under that section of the penal law. And so that's our first argument. Secondly, we go to the argument in regards to even if this court should find that the complaint should not be dismissed against Mrs. Houck and her in the entirety, we go to the idea that the acts that occurred, and recall, these are claims for intentional torts. They're claims for...
You're going now to the after 17?
That's right, the after 17. So these are claims for intentional torts of assault and battery. These are not negligence claims against institutional defendants. And it's our position that after the plaintiff turned the age of 17, any acts alleged they're not claims that can be revived under the CVA. This court, as you know, and Judge Bannister and Judge Smith were on those panels. There are two decisions out of this court, the Druger decision and the Shapiro decision, which held that in those particular cases that in order to revive the statute, the plaintiff had to put forth pleadings of facts that there was non-consensual conduct after the age of 17. In that case, as you are fully aware, the plaintiff did do that because he alleged forcible compulsion and forcible conduct. In this case, there is no such allegations towards Mrs. Houck, either in the pleadings or as shown through the record evidence. Plaintiff testifies that he was in love with Mrs. Houck. He planned to move in with her. There's, other than this statutory prohibition of them having conduct, there was no lack of consent. And we put that forth in our briefing fully for the court to consider.
Thank you.
Thank you.
Mr. Sandler?
Good afternoon. May it please the court.
I'm going to start off by the same question, okay? Whether or not the text and purpose of the Child Victims Act requires that the conduct constitute a specific sex crime under the current penal law or the law as it existed then?
Well, our position on this appeal is that the conduct is contemplated under the 1980 sexual abuse statute. So that's not...
So for you, it doesn't matter either.
It's not a hurdle for us that we have to overcome. We're not trying to argue that a sexual abuse, that some portion of Article 130 that was only brought in, 10 years ago or 15 years ago should be read to be retroactively applied.
Okay.
My name is Hugh Sandler, and I represent plaintiff respondent John Doe on this appeal. At bottom, Your Honors, Mrs. Houck really has two arguments. First, that before 2001, and really for the entire 20th century, it would not have been illegal in New York for her or any other woman to sexually abuse a child or anyone else. And that is obviously a radical legal position. It's incorrect, and it should not be adopted by this court. Her second argument is that she is entitled to defenses. Here, that consent is deemed at the age of 17. She's entitled to affirmative defenses that are actually only available to criminal defendants in criminal prosecutions, and that she's entitled to these defenses to defend herself against plaintiff's civil complaint. Mrs. Houck is not being prosecuted here for criminal sexual assault. She's being civilly sued under two causes of action, civil assault and civil battery. She's not entitled to pluck from the criminal law defenses that she likes, but that are not applicable to those causes of action. I can go into in more detail into the problems with both of these arguments, but if the court has any questions about either of them specifically, I'd be happy to address them. Okay. Well, fundamentally, I guess Mrs. Houck's arguments hinge on the incorrect contention that plaintiff's CBA claim cannot proceed unless the alleged conduct violates New York penal law. That has been roundly rejected by multiple appellate division courts this year and last year. It was rejected in Anonymous versus Castanola. It was rejected in SH versus Diocese of Brooklyn. It was rejected in Shear versus Fitzgerald. And just 2 months ago, it was rejected in W versus United Synagogue, which is a First Department case that is not cited in our brief because it was only issued after we had filed our brief. And the site for that, to the extent the court wishes, is 194 NYS 3D 25.
One
all
more
of
time.
those.
194 what?
One more time, please.
Yeah, 194 NYS 3D 25. It was issued on August 24th of this year.
Thank you.
In all of those cases, the defendant is saying that they should not be subject to CBA liability because of the defense available to them under the criminal law. So in Castanola, they were saying that the wrongdoer was an infant, and under the criminal law, an infant can't violate Article 130. The court said no. It said you do not get to use an affirmative defense available under the criminal law in this civil action under the CBA. And the other cases do similarly. In other cases, they were trying to get the benefit of out-of-territorial defense, saying that because the conduct was outside of New York and the criminal law wouldn't prohibit, New York criminal law wouldn't prohibit conduct outside of New York, they should get the benefit of that defense. Again, the appellate division said no, you do not get to use affirmative defenses in the criminal statute to defend yourself in the CBA action. And in Monroe County, so in a court in this department, the defendant said that they should get the benefit of the consent defense, identical to what Mrs. Houck is arguing here. And the Monroe County said no, and they applied those other decisions and said no, you do not get the benefit of criminal defense, affirmative defense under criminal law in the CBA civil action. All you get, and as it's stated in Anonymous, is that when you look at the CBA, you get conduct which would constitute a sex offense under Article 30 refers to conduct described in the enumerated provisions of the penal law. And then the Anonymous court, which is the second department, is clear when it says it is not limited to those situations in which the conduct would subject the actor to criminal liability. So
I think you made that very clear.
Okay. The other point that Mrs. Houck raises on this first issue is the ex post facto issue. That it would be unfair to ex post facto bring a claim against her that she didn't know was a crime against her at the time, or to use a new crime against her old conduct.
Okay, and you're going to say it's not ex post facto, does not apply in this at all. Okay, so your argument?
My argument is that ex post facto applies in criminal cases, not in civil cases.
That's what I just said, so it would not apply in this case. Okay. Anything else?
I'd like to turn to the age 17 issue, Your Honor, unless you have any questions. So Mrs. Houck's position is that all conduct once plaintiff turned 17 is barred. That once plaintiff turned 17, he obtained capacity to consent, and therefore he cannot sue for violations under Article 130, absent forceful conduct. But again, this is the same problem that I've just gone over on those other cases. Criminal law defenses, which are only available under the criminal statute, such as at age 17, you are presumed to have capacity to consent.
But counsel, that's not a defense. That's an element of the crime itself. Consent.
It is not. But we're not proving up the crime. We were suing Mrs. Howe for sexual abuse and prosecuting her criminally for sexual abuse, then, Your Honor, you'd be 100% correct, and we would have to show that. We are suing her civilly under the CBA for civil assault and civil battery. We still have to show lack of consent. There's no doubt about that. We haven't disputed that. We just don't have
But whose burden is that?
to show a lack of consent. We will have to show at trial the consent.
No, I know, but when, in
Not at
the.
trial.
Go ahead. At this stage, whose burden is to show that there was no lack of consent, that there was consent?
Right, I understand, Your Honor. What we are showing is that there are tribal issues of fact as to consent, and that we need a trial to resolve it. Does that answer your question, Your Honor, or?
It's fine, okay.
As a plaintiff, it's our burden to show that she violated the civil assault and civil battery cause of action, and both of those contemplate consent as an issue. So we would be showing at trial that he lacked consent, but we would have to show it, to Judge Ogden's point, we'd have to show it under the civil standard for lack of consent, not under the criminal standard for lack of consent. And under the civil standard for lack of consent, it's a question of fact. And what the lower court accepted this argument and rejected defendant Houck's argument because the lower court found that because defendant Houck began abusing plaintiff prior to him turning 17, she vitiated his ability to consent. Further, and therefore it's at least a question of fact as to whether he could adequately consent even once he turned 17. Second, and apart from that, there is a legion of case law cited in our brief that in a teacher-student context, consent must never be presumed. In fact, it is the power imbalance of teacher-student relationship creates duress that vitiates the ability of the student to consent to sexual conduct. We cited to the Restatement Third, which has been promulgated by the American Legal Institute, which provides a precise example as an illustration in its text of our case. A 30-year-old teacher approaches an 18-year-old senior in school. That the teacher expresses an interest in having sexual relations with the student. The student then goes along and has sexual relations with that teacher. And it is found that that would be civil battery. It is because of the relationship. And that is backed up by at least 15 cases that we have cited in our brief. Now,
But counsel, let me ask you a question. Would you say that she met her burden by saying that he was a willing participant? That was what he said, what the plaintiff said in the deposition transcript, that he was a willing participant in having sexual relations with her. Does that enable her to meet her burden and then shift that burden to you to establish a question of fact?
you mean to make a prima facie case that there was consent? Well, Your Honor, we would argue that there is no basis if he had no ability to consent because of the relationship.
Wait a minute.
After 17, I'm talking about.
Yeah, I understand, but
Asking you, and I believe that's what Justice Ogden is asking as well. Do you think they met their initial burden?
did they meet their initial
You
burden?
wouldn't even have to show their issues of fact.
Right.
No, I don't think they met their initial burden because they never got over the hump that consent was vitiated by the fact that Mrs. Howe had sexually abused the same student prior to him turning 17, which was the basis that the judge found at the lower court.
Do you have anything further?
Well, just secondly, that in addition to both the legion of case law showing that teacher-student you can never consent, the vitiation at age 16, there is also a question of fact as to the actual conduct. We have put tons of evidence into the record to show Mrs. Howe's grooming, Mrs. Howe's power dynamic that she wielded over the student, the control that she had over the student, and the access that she had over the student, which all of which, when it's considered in the light most favorable to plaintiff, as you'd have to do here as we're opposing summary judgment, raises a question of fact at the civil standard, and it raises a question of fact even at the criminal standard. Because even under the criminal standard, it is not a fait accompli that just because you turn 17, you have to have consented. For a sexual abuse, and the statute is very clear, for sexual abuse under 130.05, there the court has to consider all of the circumstances around the nature of that sexual abuse. So
And we understand all that. Do you have anything further?
Well, I'd like to just say that the Gruber and Shapiro cases do not apply here, because in Gruber and Shapiro, they were talking about forcible contact. The Fourth Department did not hold that you have to apply criminal penal standard, the criminal consent standard to revive a CPO claim. And what Mrs. Houck is actually asking you to do is that she's inviting you to create a appellate division split authority, because the Second Department and the First Department clearly set up a
Thank you.